Court rise. Appeal in the matter of News Corp UK and Ireland Limited and the Commissioners for Revenue and Customs part heard.
Sorry about that, Mr. Peacock. There seems to have been some wires crossed.
Lord.
Right. Just give me 1 second, if you don't mind. Right.
Lord, I stand, my Lord, because this morning your clerks may have received only a few minutes ago an attachment which is the document I mentioned yesterday, the terms and conditions for the supply of these services, as the document before the First Tier Tribunal, which is not in your bundle. It's at, it was an exhibit. The reason I haven't handed up a paper copy...
I have not received it.
No, I haven't got it either.
I don't need to take you through, it's just to say that's what's coming your way.
I just got it on an email.
The reason I haven't handed up a physical copy, the only one I have has all my scribbles on it, and the papers within the commissioners are now in storage, and because of COVID-19 they can't be accessed. But what you have is the original, I think the exhibit was MF10, exhibited to Mr. Flanagan's witness statement before the FTT. It just says
Right, I've got 2 notes from Mr. Peacock and the case of Lloyd's Bank.
Yes, we've just received those.
And Lady Justice Rose, I think, has just forwarded to me. Terms and conditions.
That's all it is.
Thank you.
It answers the more detailed questions that your Lordship was asking about what is included in the service.
Right, thank you very much. Good, so we're back to Mr. Peacock.
Well, just in relation to the terms and conditions, the court will allow me a little latitude. I don't quite know what I'm going to say about them yet, but if need be, I can come back and deal with them very shortly.
I would have thought so. That would be sensible, yes.
You have received from us the 3 things that you identified a moment ago. I will explain the significance of each of those documents in due course, but I was proposing to start, in light of the invitation from the court yesterday, with the note on the European law.
Yes.
Which is to start at the other end of the line of reasoning. So what we have done in this note is to start with Article 110, but to attempt to identify where it sits in European law by looking at its background, its role, and then at the requirements of Article 110. And I don't propose, unless it's helpful to the court, simply to read the note out, but if I just walk or step through it.
Yes.
We identify in paragraph 2, 0 rating as the product of legislative choices made by the UK prior to its accession. The detail doesn't matter, but newspapers were not charged purchase tax. Purchase tax was introduced in 1940. As a footnote point, there was an initial proposal that would extend to books and newspapers. There was a large row then in Parliament, and the then Chancellor backed off. One can see rather touchingly that they had time in 1940 to spend time in Parliament arguing about the purchase tax treatment of newspapers. But it wasn't subject to purchase tax. Purchase tax as a regime lasted until 1972, when it was replaced by VAT. That replacement by VAT being in anticipation of our joining the European Community on the 1st of January 1973. So the legislation that we're here concerned with is the Finance Act of 1973. 2, if you want to see a little about the transition from purchase tax and the run-up to the VAT regime, it is discussed in the Taylor-Wimpey decision, which is an Upper Tribunal case, and we've given you the references.
Yes.
Now, that freedom conferred on the UK and other member states to maintain prior treatments exemplified what I said yesterday, that this system is not perfectly harmonised. And one of the consequences of that, as we saw yesterday, is that there is no EU law right to a zero rate. That is the product of national legislation. That's Marks and Spencer's. Now, that, as a consequence, means that a zero rating in the UK must sit within certain boundaries imposed by European law, the most obvious one of which is the requirement to comply with the 5th indent of Article 17 of the second directive. But within that boundary, questions of statutory construction are matters of UK law. Where does Article 110 sit in the rest of the directive? Well, as we say in paragraph 5, it's contained in Title 8 dealing with rates, Chapter 4 special provisions, those special provisions operating until the adoption of definitive arrangements. And that was the expectation, that there would be a definitive harmonised system across Europe, and that point has not been arrived at. In the UK's case, we are going to leave before that point has been arrived. Article 98, by contrast, is contained within Title 8, Chapter 2, Structure and Level of Rates, and in particular Section 2 dealing with reduced rates. So we then identify in our paragraph 6 the distinction between the different chapters. Chapter 2 including Article 98 setting out the general structure of standard rates and reduced rates, and those are harmonised across Europe, although the actual rates that would apply in a given circumstance in a given state may differ.
Have we got a sufficiently large extract from the PVD for us to see it all in context in the bundle?
Yes.
Yeah, thank you.
Now I'm going to show you in a moment, because I need to expand on one of the points in this note just to take you to that legislation.
Thank you.
Mr. Brown reminds me that if you have the ability to use the footnotes 1 and 2, the links, either directly
Footnotes 1 and 2 in the note.
in the note, that will take you to the full legislation.
Oh, right, okay, thank you.
There is a consolidated version of the PVD available
On your
on
list.
Eurolex. Yeah.
And then Chapter 4 creates or recognises special provisions, which are those that are adopted pending definitive arrangements, but no harmonisation as yet. So then the requirements of Article 110, or how does it apply, we identify in 7. It preserves the concept of exemptions with deductibility, as at 1st of January 1991. Now, at that date, there were 12 member states. It only moved to 15 in January of 1995. And just for your note, in case it becomes relevant, there were 9 member states when the UK joined, but then 3 member states joined in the 1980s. So it was Greece, Portugal and Spain. And they had joined by the time of 1991. So there had been new acceding member states after the UK had joined and before 1991. And then Sweden, Finland and Austria came along in January 1995. The significance of that we will see in a moment when we come to see what has to be bolted on to Article 110. So, accepted the UK zero rating is an example of an exemption with deductibility. But, as we we make clear over the page and by reference to footnote 4, if a member state applied a zero rating which was not consistent with the second paragraph of what is now Article 110, then it could be the subject of infraction proceedings, and that was the debate in European Commission in the UK in 1988 as to whether particular zero rates in the UK complied with clearly defined social reasons or for the public, for the benefit of the final consumer.
And inconsistent with general principles of community law, would that also lead potentially to infraction proceedings?
Yes, and I'm going to
Sorry.
come on to deal with that aspect. So 7.2, a reference to community law must be taken as meaning the general principles of community law as established in the community's constitutional framework, in the treaties and the jurisprudence of the court. That's what brings general principles of EU law in. But it does not thereby, could not thereby, bring in Article 98, for example, because there would necessarily then be a breach of Article 98 in circumstances where you were permitted a zero rate. Those two rules could not sit side by side. And so what we say in 7.3 in consequence of all of that is the principles of community law that arise on this appeal, footnote 5, it being recognised there's no challenge to clearly defined social reasons or for the benefit of the consumer. So first, the principle that derogations from the harmonised system should be construed strictly and so as to give effect to the purpose of the provision. It's been shown, Lord Kitchen in SAE, my own friend took you to the observations of Lord Justice Chadwick, the Expert Witness Institute, and we've given you those references again. And then B, the principle of fiscal neutrality. As we say in 7.4, other principles will arise in other cases, so legal certainty, proportionality, non-discrimination, but they are not material to this appeal.
But if the Commission took the view that the approach adopted by the UK courts to strict construction of the existing provisions allowing for zero rating was not consistent with the standstill or had not adopted a sufficiently strict construction, is that something that could lead to infraction proceedings?
And not related to the head of zero rating that we're concerned with, but that in effect was what was going on in part in the Commission against the UK. So it has always been open to the European Commission to bring infraction proceedings if they thought that a zero rating in the UK was being applied or understood or construed in a way that offended what I've described as the boundaries set by European law. Now it is for those reasons that we say in our paragraph 8 that the Upper Tribunal was correct in its approach to this area of the law, identified rightly that Article 110 is the only relevant provision, preserves the domestic choice made by the UK, no material change since prior to entry, although we do need to look at the note that was introduced in 1978, and I'll do that in a little while. But we say in 8.3, the material relied on by the Commissioners, below and in this court, in relation to Article 98 reduced rates, is not of relevance.
And that's not because it relates to reduced rates rather than zero rates, but because it relates to the harmonised part of VAT law rather than the unharmonised bespoke area.
Well, it is both. Both are true. order to add some colour to what we say is the non-relevance of the Article 98 material that you were shown by my learned friend, it would be helpful to turn up the legislation. I want to start with Articles 96 and 97. They are in the Authorities bundle at page 22. So what you should see here is right-hand column, Chapter 2, Structure and Level of Rates.
So I didn't catch the page.
Page 22.
Thank you.
Right-hand column, bottom of that right-hand column.
This is the 6th directive.
This is the principal VAT directive.
Oh, this is.
So Article 96 provides for a standard rate of VAT. Article 97 provides a minimum rate of 15%. Then Article 98 permits one or two, either one or two reduced rates. The reduced rates were permitted in the harmonised world, but they could only apply to goods or services in the categories listed in Annex 3. That's 98.2. And we're also told, second paragraph of 98.2, top of page 23, that the reduced rate shall not apply to the services referred to in point K of Article 56.1, and they're the electronically supplied services. Now, we know from Annex 3.
Just remind me, was there anything in the recitals that explain why electronically supplied services are taken out of the reduced rate regime?
Not in the principle of that directive as it was originally enacted, I think, because electronically supplied is not at that stage in time.
No, I mean in the recitals of the directive that inserted it.
I don't immediately recall, my lady, but perhaps Mr. Brown behind me can look whilst I continue.
I think we saw the directive that
We
inserted
did,
it.
yes, but I don't. Don't let me interrupt you now, but it might be useful to understand, if it's possible to understand, why it was thought that they should be taken out. But let's carry on going through.
Perhaps if I just mark the point, I'll come back to it later. The point I was just making is that we know from Annex 3, which is page 29, that reduced rates could apply to things in item 6. Just pausing there, we know that you can't have a harmonised reduced rate for an electronically supplied service. And we know from the implementing regulations that my learned friend showed you the other day that a printed newspaper is not an electronically supplied service. There's nothing unusual in that. So there's a bar on applying a harmonised reduced rate to an electronically supplied service, but you can apply a harmonised reduced rate to things in item 6 on page 29. Now, what was permitted to be the subject of a harmonised reduced rate in item 6 changed from time to time. my learned friend showed you yesterday. So what you see on page 29 is the original iteration, if you like, where it just refers to books, then ignoring the words in brackets, newspapers and periodicals. And then after May of 2009, the words on physical means of support were inserted. And we see that from page 38 of the bundle. So if one wants to compare, it's the language of page 38.6 with the language of page 29.6. So from 2009 onwards, you could have a harmonised reduced rate for books on all physical means of support.
You keep on talking about harmonised as if it's a term of art. It's not, is it?
Well, that's shorthand for under Article 98.
Yeah, but the problem with that is that Article 109 explains that Chapter 4 applies pending introduction of the definitive arrangements referred to in Article 402. So what are they?
Well, that was the expectation in 1977 that there would be a fully harmonised VAT system across the whole. And that point has never been arrived at.
Well, no, of course not, but there has been further harmonisation, presumably, as they've introduced new harmonised provision. For example, the parts you've just been sharing us.
Lord, if your Lordship's observation is that the world gets slowly more harmonised, then broadly that is true.
What I'm trying to understand is why the European law exclusion from reduced rates or zero rates of electronically supplied services is not part of a arrangement.
It's not part of the definitive arrangement that was foreseen in 1977.
Well, can you at some point show us Article 402 that tells us what the definitive arrangements are?
Well, yes, we can do that, but if I answer your Lordship's question, it was the expectation from as far back as the 6th directive that there would be a fully harmonised system across Europe that would sweep away all of the derogations and special when member states acceded to the Union. That point has never been arrived at. So we have not.
So page 38 is the change that was made to point 6 of Annex 3 in 2009.
It is, my lady.
Was that the same directive as introduced the exclusion of point K from Article 98? Or did that come later?
Isn't that Annex 2?
No, if one goes back to page 20, electronically supplied services were first identified as a relevant concept in relation to place of supply rules, which is why you find their first expression in Article 56 1K, and that referred you to Annex 2. But that cross-reference was then used in Article 98, page 23, to say that the reduced rates provided for under Article 98 shall not apply to electronically supplied services.
Yes, I'm just trying to get the chronology in my mind. At some point, I think you said after the Principal VAT Directive was originally enacted, or maybe that's wrong. What was this wording in Article 98? The reduced rates shall not apply to the services referred to in point K of Article 56(1). Was that in the original text of the PVD? It may be it is, because this seems to be a photocopy of a page in the 2006 Official Journal.
I think that is right, my lady, yes.
Right. So that was introduced to exclude e-services, but then later the Annex 3 was expanded to include books on CD-ROMs and things like that.
Well, there are two things going on in Article 98. We're told that a reduced rate cannot apply to certain things, and they are electronically supplied services.
Yes.
And we're told that reduced rate under Article 98 can apply to other things.
Yes, but the expansion of it to include books on CD-ROMs occurred in 2009.
It did.
But by that was in the context of it already excluding electronic supplied services, if we're right in thinking that exclusion of point K was in the original VAT directive.
Yes. And the only thing that thereafter changed was that the reference in Article 98
It's just a little counterintuitive, because one would have thought that CD-ROMs came before electronically supplied services as a concept, but it seems that the directive dealt with them in a different order.
Is that because it was introduced in relation to place of supply rather than...
the question of what rate.
Yes.
That's part of the answer, my lady, but also because electronically supplied services was about lots of things other than the delivery of a quotes book.
Yes, yes. But sorry, this is the last thing I'll say on this point. They clearly then didn't regard books on a CD-ROM as being an electronically supplied service within point K.
My lady, yes, because the progression of point 6 of Annex 3 is to start with what was let's just think of a printed book.
Yeah.
Its second iteration from May of 2009 was to refer to books on all physical means of support. The extension thereby covering a book that might be provided on a CD-ROM. But from 2009 to 2018, there was no further legislative change as would deal expressly with e-books that one might download on a Kindle. Now, in order to see what happened between 2009 and 2018, we ought to look very quickly at three decisions of the European Court in chronological order. Now, they are not a necessary part of my case, but they are relevant to understanding what's wrong with my learned friend's case.
Can you just explain what the decisions are, please, and what you go to them for?
KOI is a decision in 2014 about the comparability of paper books with books on physical means of support. European Commission in Luxembourg, which is March 2015, is a case about the comparability of paper books with e-books. And the court there concluded that the Luxembourg legislation did offend Article 98, because Article 98, prior to 2018, did not permit a reduced rate for an e-book. And then the last case is the RPO case, which is March of 2017, which is a comparison between e-books and digital books on physical means of support, and in particular, whether there was an offence to the principle of equal treatment or fiscal neutrality. And the court said, in principle, yes, but that result, while unpalatable, is required by Article 98. And so what that chronological development of the case law establishes is that it was Article 98 which was preventing member states from applying reduced rates to e-books.
And just pausing there, so sorry, if those member states had an exemption for a zero rate for books and interpreted books as e-books, so they were in the domestic, non-harmonised situation, they could have done that willy-nilly.
Subject to compliance with the boundaries I have set on my EU field.
Well, if you're right about newspapers, then doesn't it follow you're right about books?
Provided that they were for clearly defined social reasons for the benefit of the final consumer, properly comparable.
So all this stuff is happening in relation to a reduced rate, but you can zero rate to your heart's content.
Provided that was the terms upon which you acceded to the European Community.
Yeah. Okay. Sorry, I interrupted you.
So the UK couldn't have decided, let's take a close example, the UK couldn't have decided that it would suddenly zero rate television streaming, the modern form of streaming of films and television programs. But if I am right, it was a necessary part of the agreement that the UK arrived at on accession that it would be permitted to zero rate newspapers, and if applying UK principles of statutory construction, including always speaking, that extends to digital editions of newspapers, then that is to be respected. And there is nothing in the debate in Europe about Article 98 reduced rates that is offended by that, nor is there anything in that debate that leads to the 2018 directive that tells you whether I am right or wrong.
The thing that worries me is that digital newspapers, let's assume, do not exist before when they exist, the EU decides that they are not to have reduced rates or zero rates. But at the very same time, the construction under English law includes something that can't be included under European law as zero rated, which obviously happens at a point in time. I mean, I don't think the exact date can ever be pinpointed, but at some point, the always speaking principle converts physical books on your case into allowing zero rating of digital books. But at almost exactly the very same time, the EU decides under EU law you can't do that.
Well, it doesn't.
Well, you say it doesn't because you say that you take no regard. You've got two entirely separate regimes, and never the twain shall ever meet. But I'm questioning whether that's really the correct approach. I don't quite see the statute in the legislation in the way you do, which is that this is a carve-out forever, whatever happens in the future, provided English law allows a sort of remarkable always speaking principle to change the meaning of an earlier statute. I mean, it's counterintuitive to me, I'm afraid, because it's a carve-out of such unlimited scope.
Well, it may be counterintuitive to your Lordship, because your Lordship has now become used to dealing with VAT disputes, where you always start with a directive. And
No, well,
often
it's
you
something
finish
we
with
said
the
yesterday,
directive,
yes.
and you never really bother looking at the UK legislation, because you know we have to implement the directive. And in 95% of cases, that will be the right approach and the right answer. 99% of cases. But where you are concerned with a zero rate, with respect, that is not the right approach.
Well, I mean, it's not just a zero rate. You make this distinction, but the article in question refers to reduced rates as well.
But it refers to reduced rates that member states prior to accession
Yes.
had adopted.
Yes, so the distinction is that's not the relevant distinction. The relevant distinction is, does the carve-out continue? Can the carve-out be extended to cover something that the EU, in your language, the harmonised system, has excluded?
Well, look, we could test it this way. Let's imagine the Finance Act 1972 said, as regards newspapers, not that they would be zero rated, but that they would be rated, say, at 2%.
Yeah.
Now, that would be a reduced rate that was adopted by the UK. Well, let's say it could have been under purchase tax. It could have been a 2% rate under purchase tax.
Yeah.
That would have been preserved by what is now Article 110.
Mm-hmm.
And whatever the EU came later to think about the scope of the Article 98 reduced rates, the UK's choice made prior to accession would have to be respected.
But that's not the situation here. I mean, it's an unhelpful analogy because you're still talking about newspapers throughout that debate. So if it's a carve-out, it's a carve-out. What we're talking about is the change in the proper meaning of the carve-out as a result of technological developments after the date on which the carve-out was agreed.
Well, Lord, yes, but if my starting point is respected, the carve-out has to be respected, and all this stuff about Article 98 doesn't bear on that question, nor on whether I'm right or wrong about always speaking a newspaper, then the debate does come, in my respectful submission, back to questions of UK statutory construction, because we are playing in a field that is bounded by European law, but I am not offending a relevant principle of European law.
Because you say the word newspapers in Annex 3 means something different, or can mean something different from the word newspapers in item 3 in the ATIA.
Yes, because ultimately we're here concerned with what was meant by the drafter in 1972. 2. Now, I did promise just to show you one thing that does bear upon this debate as to what happened for member states who acceded after 1991. I invite you to turn in the bundle to page 24. So you will find Article 110. And that preserves what it preserves. And then Article 111 makes special provision for Finland and Sweden, who acceded in 1995, so that they were permitted to continue to zero rate, A, in the case of Finland, newspapers and periodicals sold by subscription, and B, Sweden, in respect of the supply of newspapers, including radio and cassette newspapers. So that, at that time, respected the legislative choices made by Sweden and Finland prior to their accession to zero rate either newspapers or newspapers including non-print newspapers.
But why did Finland need that?
Because Finland,
Oh, yes, sorry.
they acceded after 1991.
And
they
so
couldn't-
presumably in 2004 there was a whole slew of additional exceptions for the 10 who joined in. I don't, yes.
Well, there was, but if one runs an eye quickly down 115 onwards, so 115 applies to all member states, 116 is Portugal, 117 is Austria, and then 1, 2, 3 onwards, Czech Republic, Estonia, Cyprus, Hungary, Malta.
So does that mean those countries didn't have a newspaper or book equivalent? Is that why 111 is limited to Sweden and Finland?
Well, 111 dealt with what had to be dealt with on the accession of Finland and Sweden, and then the other temporary provisions deal with the accession of the other member states, and none of them, so far as we can see, refer to books or newspapers.
Right. Cyprus had a zero rate for ice lollies. They were allowed to maintain that in place.
For two reasons. One, that was the legislative choice made by Cyprus, and two, that was a part of the deal they did at the point of accession.
And ice lollies are, of course, contributing to social...
Maybe in Cyprus they are, but...
Very hot.
It's very hot, yes.
But if the European Commission thought that was not right, then they could have pursued it on the basis of not clearly defined social reasons or not for the benefit of the final consumer. Yeah. I confess I don't know whether they have pursued that line of argument. But what the other paragraphs that are added, the other articles that are added on as more states accede, reflect, is that the deal that was done at accession is to respect the systems that were adopted prior to accession, provided they comply with certain principles. And we know in Article 111 that it does include newspapers, but it also includes non-print newspapers. So what I was going to show you, but I'm not sure I need now, but if one looks at the proposal for the 2018 directive and then the various recitals, one will see that it's designed to deal with the world that the court saw in the RPO case. And it's designed to amend Articles 98 and 99.
Sorry, I didn't catch what you were saying. What's designed to amend Article 98 and 99?
The 2018 directive.
Oh, yes, sorry. Yeah.
So just for your note, the proposal you were shown at Authorities 637.
Yes.
And the directive is at Authorities page 40. maybe you were shown a press release from the Commission at 637 and the proposals at 641. But the purpose and effect of that change was to amend Articles 98 and 99.
Mm-hmm.
It was to confer on member states the ability to have reduced rates that otherwise would offend Article 98. And that was seen to be necessary by the Commission in light of the case law of the Court. Changes were made. Member states were then permitted to have Article 98 reduce rates in those new circumstances. All of that is true. We don't deny its existence. But its significance here, we say, is nothing. If the Court were with me so far, I have set boundaries for the field of which I want to play on that are set by principles of European law. My submission is I don't offend those principles. Indeed, I'm going to say in due course my own friend's case offends one of them, which is fiscal neutrality. So then one is left with principles of UK statutory construction, where the proposition is that you can, and here should, read newspaper to extend that which is a digital edition of a newspaper. And last 2 points, which I hope are footnote points on the European law aspect of this. You were either taken very briefly or the case of Talika was faintly mentioned by my learned friend. It's a debate we had in the first tier and in the upper tier. Just for your note, we say on analysis it adds nothing. It's a debate about a different aspect of European law, namely, can you rely on an EU law principle of one supply at one rate to zero rate the contents of a caravan that the UK had specifically decided should be standard rated. And the European Court says no. But that doesn't bear on this issue. And just for your note, Talika's at authorities page 81, and one could usefully look at the Advocate General's opinion, paragraphs 15 to 17, and the Court at paragraphs 22 to 23. And then my last point I made yesterday, but there is no relevant distinction for these purposes between goods and services. The general principle is that they should be treated the same, certainly as regards rates of tax. And that is the Court in the RPO case, authorities page 233, the Court at paragraphs 49 to 50. I showed you quickly the Advocate General's opinion at paragraphs 46 to 49.
What were the paragraphs in the judgment again?
Court at 49 to 50, and the Advocate General at 46 to 49. Just one more point. The significance of the extra authority that we included on the email this morning was this. It's a judgment of this court, my Lady Justice Rose, in relation to that grouping. One of the arguments in that case was whether one should pay attention to the European Commission's view of how the legislation worked. And the passages are highlighted in the report we sent you, but the background is paragraphs 1 to 6. The issue is paragraphs 26 to 27. And then my lady made clear that what had to be construed was the legislation, and I paraphrase, whilst the Commission's view was interesting, it wasn't determined. And that's paragraphs 116 to 117. So that's the only significance of that. So that's my starting point now, my new starting point, European law. Second stepping stone is, well, what are the UK principles of statutory construction? Shouldn't really be any debate about this. You have to discern Parliament's intention from the words used, reading those words purposively, and here the purpose is agreed, the first tier at paragraph 17. You also know you need to give effect in an appropriate case to always speaking. And we know that section 30 of the VAT Act, as it now is, provides for zero rating in the UK for goods or services, provided only that they are of a description found in Schedule 8. So to reiterate, you're not concerned with whether it is goods or services, you're just concerned with whether the item, the disputed item, is of a description found in Schedule 8. So what then of the always speaking principle? You have, in effect, seen the most relevant case law passages. So just by way of reminder, the Quinterville case is at page 430 in the authorities. And it's Lord Bingham at paragraphs 6 to 10. And that includes approval of Lord Wilberforce in the Royal College of Nursing case, and Lord Steyn at paragraphs 22 to 25. And my own friend showed you yesterday the very recent FII decision my lady drew our attention to. And those paragraphs are set out as regards the majority in paragraphs 218 to 219. Just to read from the judgments of the majority at 218, the always speaking principle is also invoked where the question arises whether a statutory expression should be interpreted as including a novel invention or activity which does not naturally fall within its meaning and was not envisaged at the time of its enactment, but which may nevertheless fall within the scope of its original intention. And words I also emphasise in 219, last few lines of the paragraph, the relevant question is, what is the construction of the provision which best gives effect to the policy of the statute as enacted? Now, the minority depart with the majority in relation to what should happen to Kleinwort-Benson. But for our part, we do not see that there is any relevant difference between them in the way that they express the always speaking principle. So one could turn up, indeed it may be helpful in due course to turn up 267 onwards. But there is nothing we say in those paragraphs that alters the test or the hurdle, if you like. Just for your note, it's 267 through to 274. And 279 and perhaps helpfully 287. And to read from the last words of 287, the minority, the focus should be on purposive construction of the provision arrived at in light of consideration of the policy of the relevant statute and the object Parliament sought to pursue. Now, we also know from the Victor Chandler case, which is approved in FII, or mentioned with approval, that the always speaking principle can be used even if it means imposing criminal sanction. Just for your note, Victor Chandler is in the authorities at 351. Passages in Sir Richard Scott's judgment are at paragraphs 4, 18, and then 20 through to 30. We also have an example, albeit in a lower tribunal, of the always speaking principle being applied in the case of VAT and zero rating, and that is the Harrier case about photo books. There is one particularly, we would say, perceptive passage in that judgment that my own friend, I think, didn't draw your attention to. Paragraph 44, my own friend is right. Perhaps we might just turn that up. It's in the authorities bundle, page 464. Judge Berner, experienced judge in this field. And it was paragraph 44 that my own friend danced rather lightly over, page 474. We would respectfully say that expression of principle by the first tier is right as a matter of law. Now, my learned friend accepts that this is right. He is candid enough to say that's what his clients do week in, week out when faced with some novel product or situation. They do the exercise that Harrier suggests they ought to do, which is to apply the always speaking principle alongside other UK statutory construction principles to discern whether a particular product should fall within the meaning of the term that Parliament used. And one can imagine a circumstance if we were concerned with some new biscuit-like product, when we know that zero rating provides that food for human consumption is zero rated, there's a carve out for confectionery, but there's in effect a carve out from the carve out for certain sorts of biscuit. So what is often faced by the commissioners is a debate about whether some new product should be seen as a biscuit or as confectionery. Or in a case we'll look at in a little while, in the case of hot food, takeaway food, is it hot takeaway food or is it food that's just served warm and walked out? Very fine distinctions. But what the commissioners are doing is in effect adopting the approach that the tribunal in Harrier said was both permissible and appropriate. So that's why my learned friend is very careful to say that his case is not put as high as you can never apply always speaking in the world of VAT and zero rating. And his genetically modified tomato example reflects that recognition. So if we have an obligation as a matter of English law, UK law here, to construe strictly and purposively, we also have an obligation in an appropriate case to construe in light of always speaking. Now, to apply always speaking, two elements are necessary. You have to demonstrate that the new fact or item or circumstance falls within the purpose of Parliament at the time of the original enactment. And that purpose is identified by the first tier in paragraph 17. And there is nothing in that policy, social goal, that requires a newspaper to be in any particular format.
But is that just the purpose? You mean the purpose is the social, whatever the phrase is?
Promotion of literacy. The second directive is phrased as for clearly defined social reasons.
Clearly defined social reasons. And that, but is that the sole purpose of the...
Lady, there are two separate elements to that. For always speaking, we have to identify the purpose of Parliament in enacting that reference to newspapers. And you have my submission as to what that is, but that is whatever it is.
But that's the literacy point.
That's the promotion of literacy, the dissemination of information, the promotion of democratic accountability. Now, separate conceptual hurdle is that you have to be able to satisfy the European Commission, in effect, that maintaining the derogation is for clearly defined social reasons. So the fact that you identify the purpose of Parliament doesn't necessarily satisfy the second directive.
Just remind me where that wording about the democratic accountability...
That was what the first tier found here was the purpose of the original enactment.
But that wording is what they devised. It's not taken from some statute.
No, it was their understanding. It's not taken from statute. Now, just to pursue that thought, my lady, those two things are strictly separate. But once you have identified the purpose of Parliament, that then allows you, if you're challenged by the European Commission, to determine whether you pass or fail the clearly defined social reasons hurdle.
Right, but is there any EU case that has said that the social reasons hurdle includes promoting literacy and...
In relation to newspapers?
No, in relation to maintaining a zero rating pursuant to Article 110.
No, not that I can think of. There's discussion in the reduced rate cases for KOI, Luxembourg and RPO about the promotion of books having special treatment to promote reading, but that's not quite the same point.
No.
But the point I was making is that there are two elements that must be present. The first is you have to identify the purpose of Parliament and satisfy yourself that the new item equally meets the purpose of Parliament, and I say here it does. As the Upper Tribunal said in their paragraph 88, achieving that purpose is neutral as to format or medium. You encourage someone at school to read the Times in the sixth form, you are promoting those social goals, whether you encourage them to read a print edition or a digital edition. But that is not enough on its own, because the second element also has to be present. My lady Justice Similar observed yesterday, maybe a news service of some sort might satisfy the first. So we all paid for the BBC's website, so that the issue became live. You might say, well, that satisfies the first limb. The second limb is I have to establish that the new tested item, circumstance, is the same genus of facts.
But before you get there, don't you also have to say that it's within the second indent or fifth indent or whatever it was, the EU social purpose?
Milady, yes. And here there is no contention against me that it doesn't. The First Tier found that it did.
Fall within the directive's social purpose.
Yes, it clearly defines social reason. And we know inferentially that that is right, because the European Commission in 1988 did not challenge the UK's treatment of newspapers. Various things were challenged, so workwear and news wire services were challenged because they were being provided to banks. The European Commission said, well, that doesn't satisfy the test. But the European Commission against the UK case makes clear there was no challenge to newspapers. So on that second limb, I have to establish that the digital editions are within the same genus of fact as a print edition. And that, we say, is not determined by whether a supply is of goods or services for that purposes. Indeed, we know from the court in RPO that that's just not a relevant factor, certainly as regards rates. So a genus of fact question is not determined by the tax classification of the supply. Instead, it has to be done by looking at the facts to see whether the two items, the original item and the new item, are the same or fundamentally similar. And that exercise was done by the First Tier. There were challenges made to that factual exercise by my learned friend in the Upper Tribunal, and those challenges were rejected. He sought permission to pursue them in this court, and was refused. And when he reserved his skeleton argument quite properly, he struck out all of that ground 3 material. But part of that factual challenge below, and which would have been pursued here but he didn't get permission, was a contention that the First Tier had only decided about similarity of content and not anything else. And the Upper Tribunal said, no, that's not right. And when my learned friend sought to revive that, he was told, likely, no, you can't. So that second note that we provided overnight to the court is to summarise, by reference to the paragraphs of the First Tier's decision, both the flavour of the evidence that they saw, that's the latter part of the note, but more importantly, the conclusions they arrived at, which were not limited to a conclusion that the content was the same or similar, but that the editions were seen by subscribers and by advertisers as being fundamentally the same or similar. Unless it helps the court particularly to walk through it, I wouldn't propose to take you and show you each of the points we rely upon. But just so you see what we've done, Paragraph 1 identifies the nature of this exercise. Paragraph 2 picks out the high points of the first tier's conclusion. And then paragraph 3 identifies the waypoints in the reasoning and the analysis of the tribunal. I should say we haven't picked out every last line, but we've picked out the important highlights. And then paragraph 4 from page 4 onwards identifies the most significant findings of fact made by the first tier on which those conclusions rested. So as regards this genus of fact debate, that in effect was the bit of the case I won in the first tier.
But yes, up to now, I mean, this claim is a claim for a refund.
Lady, yes.
So up to now, the subscription has included VAT.
My clients have accounted for that, yes.
Right. So the price that's been charged for the subscription has included VAT, but the price for the printed edition has presumably not included VAT.
Lady, yes.
But why then do you say that it's necessary not to include VAT in order to encourage people to read digital newspapers? Because the service has thrived even at a price being charged which has incorporated VAT.
The purpose is to promote literacy, encourage democratic accountability, all of the above. And that is seen by the UK as being a social good which should not be subject to that.
But it's the zero rating that must have that purpose, mustn't it? It's not paying VAT that has that purpose, because the government isn't promoting the Times.
Well, you know, it's the maintenance of a particular zero rating that must be for clearly defined social reasons.
But my lady's point is that service has thrived. It doesn't need to be zero rated in order to promote literacy. Literacy is being promoted anyway.
But the court is thereby assuming that my clients have reached the maximum possible subscribers despite the VAT burden, and therefore no harm, no foul. With respect, that's not the right test.
Well, except that we're looking backwards. This is a refund case. We're not looking at the future, because for the future it's been resolved.
Well, we're looking between 2010 and 2020.
Yeah.
Yes.
So you could never. There's nothing to promote. You've sold to who you sold to. You're not going to encourage more subscribers. What's done is done. How does it achieve that purpose? Looking backwards.
Because you have to proceed on the basis that the maintenance of that zero rating in 1972, 1st January 1973, when we exceeded, you have to ask, is maintaining that prior treatment for a clearly defined social reason? And as regards newspapers, I say the answer is yes. And if what you have done, put it the other way around, and that social good, social goal, is achieved equally by the promotion of digital editions.
So on the 2nd of May this year, did the price of a subscription to the Times become 20% cheaper?
I'm told the answer is not yet. we don't know the outcome of this litigation.
No, the outcome of this
Nothing to do
litigation
with
doesn't
it.
affect
Doesn't
that
matter.
because presumably HMRC accept that from the 1st of May you don't have to account for VAT on the subscription.
But the point, my lady, is this, that my own friend has a separate argument that was parked before the first tier, which was whether, if I am right in principle and I am entitled to the money back again, would my clients be unjustly enriched by the return of the money?
I don't think that quite deals with my point, which is that as from sales of subscriptions, as from the 1st of May 2020, you do not have to account for VAT to the revenue. Right. So what has happened to that 20% of the price which you previously accounted to the revenue?
The answer, I don't actually know, but I assume it's been invested in the Times' news gathering operation.
Yeah.
So it isn't for the benefit of consumers?
Well, promotion of newspapers.
No, the zero rating. Because they haven't had the cut.
Well, they haven't yet had it.
Well, in a time when they're entitled to it, the Times has not afforded that to them.
But my clients didn't know from 1st of May onwards whether we're right or we're wrong.
Well, you
But
know
the-
for the future.
But from the
But
1st of
your
May,
latest
the
information
government
is
has
right.
implemented the reduced rate
Mm.
possibility. Is that for a zero rate or is it for a reduced rate?
And there may be some confusion. My learned friend is talking about the period 2010 to the 30th of April, which is the unjust enrichment argument.
Yeah.
From the 1st of May, the zero rate has been applied by the order because it amends the domestic legislation. So there is now no VAT on the first three items only in Group 3 to include a 7th item, which is the delivery mechanism, be it of goods or by digital services, is also zero rate.
Right, so you're not going to require the Times to account to you for VAT at 20% on sales of subscriptions as from the 1st of May this year.
Yet, my lady, again, we are not, told if I'm wrong, no, it's zero rated from the 1st of May, and as I said, it was to be yesterday, but it was brought forward to the 1st of May. We don't want to pay 24 million, which is about the figure for the period claimed between 2010 and 2020.
No,
But it's
I
35
think we all
million.
understand
35 that's the
Yes,
unjust.
that's separate. But from the 1st of May, this case has nothing to do with the zero rating.
No,
The zero rating is there if it fulfills the social good and is for the benefit of the consumer.
Because the consumers have had the benefit of the delivery of, I say, a newspaper in the form of the Times.
Well, I think we know your answer.
And interestingly, the insertion of paragraph 7 is part of the what you would call the harmonized regime, but it's inserted into an exclusion which is part of the Article 110 regime.
Well, as a matter of UK statutory structure, it had to be done that way.
Doesn't.
Well, you have to
It was.
you have to amend Schedule 8.
So is Schedule 8 a mixture of the pre-1991 zero and reduced rates and the Annex 3 reduced rates?
They didn't, no.
Well, where are the Annex 3 reduced rates?
They're provided for elsewhere in the VAT Act.
Right.
29A. They're in various places, but domestic power is one, so we pay VAT at 5% on domestic power.
Yeah, but that wasn't my point.
My Lord's point was, is there anything significant about how the UK change was made?
Well, paragraph 7 is inserted to give effect to what you say is a liberty granted as part of the harmonised regime.
In UK terms, the amendment had to be made to Schedule 8 somehow. The way it is done is to introduce what is in effect item 7, that applies only to certain of the items. But it is interesting that what is done is simply to refer to newspapers published electronically. It doesn't alter the word newspapers. It just asks, do you have one of the items that you publish electronically? And then you get the benefit of the zero rating. So the draftsman has adopted the term newspapers, and the draftsman has assumed that that term is broad enough to cover an item called a newspaper that is published digitally, electronically. What the draftsman could have done in the 2020 order is say, we will have a separate item called a digital newspaper. But she, the drafter, didn't do
But
that.
if that's a point aimed at saying what was the parliamentary intention in 1972,
It would be a bad point, my lord.
yes.
But what it does serve to exemplify is that the draftsman in 2020 saw no difficulty with that. But it is important to note that changes that were made to the various notes between 1972 and 2020. And can I come to that in a second? But just to finish the thought off.
Show creeping digitalisation.
There is a mission creep of a particular sort, and I'll show the court in a moment. But to finish the thought off on always speaking and genus of fact, our submission is that we meet Parliament's original purpose. It is for a clearly defined social reason between 2010 and 2020. We are the same genus of fact. First Tier has in effect determined that, and there is no relevant challenge in this court. So therefore there is
But
no...
can we just tease that out a little bit more? I understand what you say about the breadth of the factual findings in the FTT and the fact that the commissioners have not had permission to challenge that. But do you accept that whether they are digital newspapers are within the same genus is a question of law for this court, and for us to make our determination on the basis of the facts found by the FTT?
I had wondered that, and I had looked and have not yet found any expression of high judicial authority, or indeed any judicial authority, as to whether that is necessarily a question of fact or a question of law.
Well, isn't the interpretation of the word newspaper a question of law, mixed law and fact? It's law as applied to the particular facts found.
As with any statutory construction exercise, the meaning of the term ultimately is a matter of law,
Yes.
and then the application of that to a given set of circumstances depends on the facts.
Well, isn't that my lady's point?
We are here tasked with determining whether some novel item is, to use Lord Wilberforce's phrase, in the same genus of fact as some original item. And my primary submission is that's an exercise of fact that this court should not interfere with. But my alternative submission is, well, if that's not right, so that it is in part a question of law, that determination of the answer to that question of law must rest very heavily on the facts as found by the first tier, for this hugely important reason, that the first tier heard all the evidence, heard the witnesses, had a site visit to the Times newsroom, and saw all the iterations of the digital editions, and had their relevant features compared, contrasted, pursued through cross-examination, pursued in detail through submissions, and this court has not had the benefit of any of it.
But I don't think anybody is doubting what the FTT found. I don't think anybody is doubting the factual circumstances. What is being questioned is whether, when Parliament used the term newspaper in a long time ago, it meant printed newspaper. It's a matter of the law, actually.
That's a matter of statutory construction. And of UK statutory construction within my field bounded by principles of European law.
Well, I'm addressing the argument you're addressing to us.
Well, can I turn then to the exercise of just looking at the...
But do you accept my Lord's point? Because I'm now a little bit confused about whether you do accept it's a question of mixed law and fact, or whether you still maintain it's just a question of fact.
No, my primary submission is that when one is looking at this notion of the same genus of fact, that is a factual exercise.
But this exercise is a question of statutory construction first. You may use that principle in order to inform that exercise. But the actual question for us is, what does newspaper mean in item 2 of group 3 of schedule 8?
My lady, the ultimate question is, as your ladyship has put it to me, and that's a question of law.
And the words genus of fact cannot be translated from a dictum of a judge into a statute. But you're sounding very much in your submission as if they are.
Not at all, no. I quite accept that one can't construe Lord Wilberforce's words as if they are statutes.
No,
Quite accept.
because they're really not. And the different expressions of the always speaking principle seem to give it some incredible life, as if it's something bigger and more important than it truly is, I think. The always speaking principle, of course, has many applications and is extremely important in many cases. But it may not be the most important thing here, because we're actually, as my lady says, construing a statute.
Ultimately, yes, you have to do this exercise of statutory construction. All I'm dealing with at the moment is one of the principles I'm inviting you to apply, which is always speaking, and I am recognising that that has two core elements to it, and that my submission is that both of those core elements are present, that engages the principle that you then use to decide ultimately your question.
And I know, I understand your argument, Mr. Peacock, I think pretty clearly. My point is that you can get the wrong result if you take one principle of statutory construction and elevate it into the only thing that you're thinking about in order to determine the larger question of what in this statute did newspaper mean, taking into account all the principles of English statutory construction.
Let me then be clear to the court, I am not seeking to suggest that the always speaking is the only principle. I quite accept that I must abide by the other principles I identified, which is to discern the intention of Parliament from the words used and to construe what Parliament has said purposively. Absolutely trite law, I am not contending otherwise. My contention at the
Otherwise we wouldn't have the benefit of Benyon if we only had the always speaking principle. And without Benyon we would all be poorer.
In all senses of the word.
Publishers of Benyon would be poorer if
I don't know how many copies.
Available on the
I
CD-ROM.
don't know how many copies they sell, but anyway, on we go.
available digitally. It is available digitally actually now. One can access it through Lexis.
Yes.
So, construction of the statutory terms in the relevant schedule and the relevant group. We made various submissions to the first tier as to whether you could imply or find or discern an intention on the part of Parliament to limit the zero rating only to that which was printed. And the first tier determined that that could be discerned for the reasons that it gave. We challenged that in the upper tribunal.
Which paragraph?
In the first tier, I've momentarily forgotten the
181, it's onwards, page 161.
I'm obliged. 13 to 16 set out the legislation, paragraphs 13 to 16, and then it is 181 onwards, page
161.
161, I'm obliged. We had the same debate before the Upper Tribunal. And that is recorded in paragraph 54 through to 59 in particular, where the approach of the first tier was found to be wrong. The Upper Tribunal accepting my submissions to the effect broadly that one cannot discern an intention on the part of Parliament to limit the zero rating to printed. And just in this connection, because it harks back to the European law debate, can I just invite the court to turn up quickly the legislation itself. Which is in the authorities bundle. Finance Act 1972, pages 44 and 45, and in particular page 45.
Yes.
So as enacted, it was 6 items, and there was 1 note. The note being 2/3 of the way down, just above the heading Group 4, Talking Books. And that expressed things that were not included. And then if we turn on to page 54, we're in a later iteration now, Schedule 8 of the VAT Act 1994. This is in 2010. You will see that there are 2 notes. The original note has been labelled 1A, The new note is note 1B. And note 1B now makes clear that it includes certain supplies of services. And that was introduced in 1978.
And what were they?
That's the undivided shares
That's right.
and the lending or possession.
So they're still services of a tangible thing.
Well, they're services in respect of goods. But what is interesting is that was not seen in 1978 as being an extension of the zero rating. Instead, it must have been seen, one can infer, seen as an articulation of the position as at December 1975, because at this point in the chronology, we were held to the position as at December 1975.
Sorry, when was Note B introduced?
1978,
Note B.
Note 1B. This is in, the easiest way of seeing this is the historical explanation in the Upper Tribunal's judgment.
But how does this take us anywhere?
It's important, harking back to the European law argument that I outlined, in that it is recognition in 1978 that the scope of the zero rating could extend to services.
Well, it's a recognition that the UK government thought it could.
And the European Commission did not infract us in 1988.
Well, they might not have, might have had better things to do. It's a very small change, that's the point.
But my lord, one can't simply ignore it as a change, bearing in mind that we were infracted later for what were perceived as perceived offences.
Yes, but I mean, what are you getting from it? I mean, on the question of proper statutory interpretation of the earlier legislation.
My lord, it has no bearing, because what we're concerned with in the UK statutory construction exercise is what did Parliament mean in 1972.
Yeah.
But that said, it does indicate that without infraction, the zero rating was extended in part, at least, to deal with services. And then there was another change in 2011, which we're not concerned with. What the Upper Tribunal said is, well, you can't take account of those later developments in discerning Parliament's intention in 1972, which is right. You can't take account of any of them. You've got to discern Parliament's intention in 1972. But if there is said by the court that there is any significance in the divide between goods and services, then I do point to Note 1B.
So what you're saying about Note 1B is that at the time that Parliament enacted that in 1978, Parliament did not think that its intention in 1972 was just to exempt goods and not services.
That is the highest I can put it.
And that it didn't think that what it was doing would be contrary to the standstill.
Correct. And we can infer that the Commission didn't either.
Because in 1988 they brought infraction proceedings for all sorts of things, and they didn't throw that one in for good measure.
Well, yes. But the exercise we are engaged in, as the Upper Tribunal get right, is to determine the meaning that Parliament sought to achieve in 1972. Now, as regards that, we stand by, and I won't repeat unless the court would find it helpful, what we believe the Upper Tribunal rightly arrived at in their paragraphs 56 through to 58. court's content with that, rather than me just walking through them, the last point under this heading is, do we discern anything useful from Group 4, which are talking books for the blind? And here, again, the relevant expression of legislative purpose must be discerned from the original enactment, which is page 45. So you will see that Group 4, 0 rates supply to the RNIB of magnetic tape, tape recorders, and parts and accessories. So although it is headed talking books for the blind, and that is clearly what was in mind, what's actually 0 rated are particular things. And none of those things are a book. So can we learn anything about the scope of Group 3 from Group 4? We say no. We know that Parliament intended in 1972 to make special provision for items of kit, generic expression, that would deliver a talking book experience to those who are blind. Parliament is dealing with a then known technology. But one can't infer from that that Parliament either did or did not intend in Group 3 to make provision for a technology not yet known.
But what Group 4 doesn't deal with, I think, is the supply by the RNIB of a talking book to a blind person.
My understanding, my lady, is that that was done without charge. There wouldn't be a vatable supply. I can't tell the court that that was definitively true, but that's my understanding.
Right, so you're not saying, well, they didn't include that because they must have assumed that it was included in books in Group 3.
No, I can't say either way, my lady. But my only point here, as a short point, is that looking at the format of Group 4 doesn't advance my case, it doesn't advance my learned friend's case. It's just neutral. So if the court were with me to this point of my argument, I would have established that it is an exercise of UK statutory construction applying the principles of which one is always speaking. I would have established that the digital editions meet the same social purpose and they're within the same genus of fact. I would have established that there is nothing in the language that Parliament did use in 1972 that expressly excludes the dealing with an item that had not yet been invented. So that would, in my submission, be an appropriate case for the application of the always speaking principle, just in the same way as the document became the audio tape in Grant, or an embryo created in one way became an embryo created in another way. Perfectly proper application of the principle for this court to conclude, modern common sense conclusion, that a digital edition of the Times is the Times. But if the court were with me at this point, then one would have to stand back and say, well, does that involve some impermissible extension of the 0 rating? And my conclusion would be no. Now, there is, let me acknowledge, there is a very fine, in many cases, distinction between being asked to extend a phrase or a word and to interpret it. If the court is with me to this point, our submission would be that this is the application of the approach that the First Tier Tribunal in the Harrier case about photo books, and it is not an impermissible extension of the category of 0 rating, not like the UK deciding that streaming television services would suddenly be 0 rated. What you've done is interpreted the term, as used by Parliament, in a permissible way. And if that is right, then I have not offended any of the principles of European law that bound my field, and I have necessarily applied relevant principles of UK statutory construction.
But the consequence is that e-books, which are to all intents and purposes exactly the same as real books, except appearing on a screen, would naturally also be covered.
Not necessarily, my lord, no.
Not necessarily, but it would depend on the facts, but it could, in most cases, one imagines, fall into almost the same criteria that the FTT found.
Anybody who published an e-book, and I do not speak for them, but anybody who published an e-book would have to establish in the first tier that there was a relevant similarity.
Well, I mean, e-books are pretty similar, aren't they? We all use them.
Many are, not all are.
No, I understand.
Some e-books now have very different content and functionality to what you might have found. I mean, children's books are a very good example. You might have a children's book in print.
Well, I can see the children's books. I'm just talking about novels that people read on their Kindles.
Or tablets.
Or whatever.
Yeah.
Yes.
They may be the same. Yes.
Well, the points that are raised in relation to the times and the various editions and their similarities are highly likely to apply in relation to those.
I'm wary of accepting highly likely, but likely, milady, yes, I accept. But again, and to reiterate, I am not speaking for the book publishers. I am only here speaking for the Times, and it's not necessarily true of all newspaper groups.
Well, it's very much definitely not the same of all newspapers, because other newspapers do quite a different kind of service from the Times, which I think we all understand. Some are like, I don't know actually. I don't know if there is another one exactly the same as the Times. I don't think there is, but
well, I'm not sure I should mention names, but I can think of one that's a serious business paper that is very close to
yes,
the
yes,
Times.
I can now think of one that's very close as well.
And one can think of an example perhaps that would be quite a long way away from what the Times does.
Yes, I can
So
think.
if the court were with me, then my clients obviously succeed, and anybody whose product or subscription or model is sufficiently close or the same as the Times' model would also succeed. Yes, that's the consequence.
And just to ask you a question, because you mentioned this unjust enrichment point, is that determined?
No.
Is it open, or
Yes.
and how would it be determined?
The commissioners raised the point in correspondence many years ago now. The parties agreed that it would be parked before the first tier to see whether I was going to be right in principle. It was left parked in the first tier where it remains. My clients have, since the success in the Upper Tribunal, encouraged the commissioners to engage in that debate as to whether the point's a good one or not. I make no criticism of my friend, but his clients have rather refused to get involved in that debate until we've had this hearing. So, if you decide against me, the point falls away. If you decide in my favour, my own friend's clients, we understand, are going to then insist on the determination, either by agreement, negotiation, or in the First Tier Tribunal, of this question of unjust enrichment.
Well, because it looks like a windfall, doesn't it? I mean, if you get this several million, whatever it is, tens of millions of pounds.
I hesitate to rise, but the word insist. We've only got to the stage of the commissioners being pressed and pressed by News UK to say we can't decide. We will need discovery, etc. That's as far as we've got.
Disclosure these days, Mr. Fleming.
Disclosure, I'm sorry. We'll have that as well as discovery.
Well, my clients, may not surprise you to know, do not accept that it would be a windfall for reasons that we can no doubt fight out before the first tier if it turns out I am right as a matter of principle. But this court
Well,
should...
this was a point we chewed over at great length in the Lloyds Bank case about if it's an unjust enrichment for you, is there anybody else who has a claim either against you or against the state?
My lady, yes, and shouldn't carp about the result of that case, but that left the burden of the tax not necessarily sitting where you might expect. Some people won, some people didn't. Some people lost out. But for present purposes, this court should not be concerned.
But it can't really affect our decision, not properly.
Well, my lord, the prospect that I am either right or wrong about unjust enrichment, not material.
Not material, no. I just wanted to know what the
whether
position
this might, a decision in my favour might then be relied upon by other newspaper groups, neither here nor there,
Right, well, and I
or
understand
publishers
that.
of e-books.
Right, I understand that too. Yeah.
Where I got to, I think, my lord, was this, that if the court were with me thus far, then we would say the Upper Tribunal did not err in law.
Mm-hmm.
And again, I could walk through it, but in a sense, you have a skeleton argument, and I've made sufficient amount out to a greater length, but you see why we say they didn't err in law.
Mm-hmm.
The point that my lord picked up was, well, did they misstate or mischaracterise the always speaking test in their paragraph 89?
Yes.
We would say no, they were alive to all the relevant principles, and they knew that they had to discern what scope there was for the application of the principle, given the language that Parliament had originally used. And read in context, that is what they are doing in their paragraph 89. We would say, respectfully, read fairly and in context, there is no error of law there.
But if we disagreed with you, hypothetically, and thought there was an error in the way that they've identified those a spectrum, then what follows from that? Do we make the decision ourselves?
Well, then you would have identified an error of law that would render at least that part of the Upper Tribunal's decision unsafe. Doesn't mean that other conclusions they came to are necessarily unsafe. But if you felt that there was a sufficient error of law that in effect one couldn't proceed on the analysis of the Upper Tribunal, then you have in any event to address all the questions of law that we've discussed. But I say, with the findings of fact made by the first tier, beyond which there is now no debate. This court, as usually, has in effect free rein over the law, but you have almost no, or here, no rein over the facts. That would then take me to my last heading. If I'm right so far, I don't need to rely upon the principle of fiscal neutrality. If I'm wrong so far for one or more reasons, then we do on the principle of fiscal neutrality was addressed in the first tier, their paragraphs 224 to 232.
Sorry, what are those paragraphs?
224 to 232. And the issue wasn't addressed in the upper tier. I'm sure this court has the principles in mind, but the principle of fiscal neutrality requires treatment for VAT purposes of like supplies in the same way. And it applies where there is relevant similarity between supply A and supply B. The fountainhead of that principle in the Court of Justice at the moment is a case called Rank, about betting and gaming. That's in the authorities bundle at page 136. And you will find expression of the relevant principles, paragraphs 37, 41, and then 43 through to 58. And that principle applies equally when we are concerned with matters of zero rating. It is one of the principles of European law that bounded my field, which I must respect, but even my learned friend must respect. And if there is a difference of treatment of relevantly similar supplies, then the taxpayer is entitled to rely on that principle so as to achieve the same treatment as was accorded to the comparator product.
Say that last bit again.
The taxpayer is entitled, as regards the disputed product or supply, to be accorded the same VAT treatment as the comparator product or supply.
So there would have been a finding on this argument that they're not within the same genus of facts, or for whatever other reason that they are that newspaper didn't extend to the digital product or digital service. But you say, nonetheless, there is sufficient relevant similarity to enable you to get a remedy in EU law, because you couldn't get it. You'd be relying on EU law for that, not domestic law.
I have lost the argument ultimately, which is a matter of UK statutory construction.
Yes.
That I am entitled in those circumstances to rely on the principle of fiscal neutrality, which is EU.
But so, okay. Yeah.
So what you're saying is following on from my lady's question, that the test for comparability for the purposes of fiscal neutrality must be a different test from the test of whether this is within the meaning of the existing legislation.
My lady, yes, in a sense that conceptually has to be right, because you have a product that is otherwise accorded a particular treatment and a different product that is not accorded that treatment as a matter of domestic law.
Yeah.
And in those circumstances, a principle of VAT law requires the same treatment, provided the two products are comparable.
Right, and you must then say that that principle of fiscal neutrality trumps the requirement of the standstill provision, so that it is permissible to extend the zero rating beyond what was permitted in 1991 if it's necessary to do so for purposes of fiscal neutrality.
And I say yes to that, and whether that proposition was right was for many years in doubt until a decision of this court in a case called Sub 1. But just to finish the walking up to that point, as we've identified, I do rely on the principle. It is applicable in the case of zero rating. Here, I say there is relevant comparability as a matter of fact, so I've satisfied the rank criteria.
But what are the differences between the test under fiscal neutrality and the test under the domestic? provision? What are the features that make the answer yes under fiscal neutrality, but no under the former?
My lady is in effect asking, how can I have a second argument if I've lost the first
Yes.
argument? And my answer is, it depends why I've lost the first argument.
Okay, so if you lose the first argument because this court ultimately takes the view that they're different in kind and dimension.
Yes, if I'd lost I'm going to call it a factual debate, and we may quibble,
yes.
but about whether they're the same genus of fact.
Yes,
If I've lost that,
yes.
then it becomes extremely difficult for me to succeed on
Okay.
the fiscal neutrality.
Oh, I see, because you answered my lady a
Yes.
moment ago that the tests were different.
Well, the point I was hoping I was making to my lady was that the principle operates in a world where you have domestically a difference in treatment between product A and product B that is itself the product of the domestic regime.
Well, I thought I was asking the same question that my lady asked.
Yes.
Well, then, if you did, my lady, then I misunderstood,
Okay.
and my answer is it depends why you're against me on the first argument.
But you're accepting that if they're not the same genus or they're different in kind and dimension, which was the other way the always speaking principle could fall, then it would be very difficult to satisfy the relevant similarity test after.
But to reiterate, and the court has the submission, I say that in effect that's a conclusion that's not really open to this court because it's been decided by the first.
Yes.
But if I lose the first argument for some other UK statutory construction reason, then we have a world in which one product that is comparable is treated differently to the other product. And that is the circumstance in which the principle is designed to apply. And here, and it may be relevant, we know from the court and the Advocate General in the RPO case that when you're considering fiscal neutrality, distinction between goods and services is not material. So that is an example. If I've lost the first argument, because this court concludes that there is a material difference between goods and services, that is not a good reason when we get to my second argument. So what we were left with before sub 1 was this nagging concern that if the UK was required to use the principle of fiscal neutrality to afford to a new product the same VAT treatment as a different, an old product, didn't that necessarily offend the standstill? And what this court decides, and I'll show you in a second, is that there is a distinction, fine but important, between interpreting an existing category, which is permitted by the principle of fiscal neutrality, indeed required in appropriate cases, and extending those categories. And it's that that allows the fiscal neutrality argument also to be run in domestic tribunals, where the debate is about something, is it a biscuit or not? Case about Pringles crisps, how much potato content did you need for it to be a potato product? And that is what Lord Justice McComb had to tackle in the sub 1 case, and so it would help to turn that up.
So it isn't a question of trumping the standstill. You say in both of these arguments, what you're doing is this fine. You're on the right side of the fine line between interpreting with all the rules of statutory construction, both domestic and European, that apply, as opposed to extending the category.
My lady, yes. Okay. Passages I'm going to show you from Lord Justice McComb's judgment work equally for my first argument and for my second. But I have to accept, because it was true that he says these things in the context of the second argument and not the first. So page 482 in the authorities, you'll find the sub 1. Now, they were a franchisee of the subway chain. This is a debate about hot takeaway food, and they provided toasted sandwiches, toasted subs, what were called meatball marinaras. We probably don't really need to know what was the makeup of a meatball marinara, but it was a form of hot takeaway food. And hot takeaway food is an exception to the food for human consumption. So food for human consumption is 0 rated, hot takeaway food was standard rated, and the complaint of sub 1 was that the Commissioner's treatment of toasted subs and meatball marinaras offended the principle of fiscal neutrality. And so His Lordship's judgment begins page 486. Just for your note, it'll make sense a little later on, Miss Whipple, as she then was acting for the appellant, and Mrs. Hall was acting for the commissioners. His Lordship begins at 486. And then if we turn on to His Lordship's paragraph 32 on page 496 of the report, he has a heading, "The Arguments and My Own Conclusions." Part of this...
I'm sorry, that page again?
Page 496, my lady, paragraph 32. So, heading, "The Arguments and My Own Conclusions." Now, part of the debate here was about statutory construction of the UK's hot takeaway food rules and how they'd been understood and whether you applied an objective or a subjective analysis of those rules, and we're not concerned with any of that. But page 501, paragraph 51, His Lordship has a heading, "Fiscal Neutrality." He identifies the issues divide up in this way. Has the principle of fiscal neutrality been broken on the facts? If so, did the breach stem from a failure of implementation or of non-application? And then 5 lines down, on either of these hypotheses, what are the consequences for this appellant? And he walks through those questions following the approach adopted by Miss Whipple for the appellant in her helpful route map. And he then sets out 54 and 55, bits of the principle of that directive, including Article 1110. That's 54. Then 55, top of page 503. In demurrer to the appellant's case on the first question, has there been a breach of fiscal neutrality, the respondents raised 2 preliminary points. Now, 56 is the first preliminary point about permission. Not interested. 57, the second point, was a point of law, namely that the EU principle of fiscal neutrality cannot have the effect of overriding the UK's socio-political decision to exclude certain hot takeaway food from the 0 rate exemption. So this is the Commissioner's argument. They're saying, we've made this choice, principle of fiscal neutrality can't override it. So we've said food is 0 rated, hot takeaway food is standard rated, UK's choice, EU law can't interfere. So reading on, the decision taken by the UK could only be supervised at an EU level insofar as the measures taken fell outside the scope of a concept of a clearly defined social reason. Deals with the permission to appeal point at 59. So then 60, can I invite the court to read 60 through to the end of 64?
Well, the answer really is in the quote in paragraph 68 from Marks and Spencer's, paragraph 36 on page 507. Which expresses in a slightly odd way, assuming that the member state must have misinterpreted its own national legislation by excluding supply B from the benefit of the maintain zero rating.
My lady, what happened in sub 1 is that the judge had to address the question as a matter of principle. Did this approach to fiscal neutrality necessarily mean, or indeed in that case mean, that you were offending the requirement to maintain the standstill? And he says no. Doesn't necessarily mean that, and it didn't in that case.
Where does he say that?
That's in his approval of what Mr. Justice Arnold had said in paragraphs 60, approving the judge at 80, and after he's dealt with Deutsche Bank in paragraph 64. But what the significance of the case itself, which I haven't troubled you with, but you both should now need to know, is that the taxpayer turned out to be wanting to insist upon the same treatment you had been afforded to somebody else wrongly.
That's in sub 1.
Yes.
Yeah.
Sub 1 was saying, as it turned out, our competitors got zero rating when they shouldn't have done. We must be entitled to the same zero rating. And the judge says, yes, fiscal neutrality applies, notwithstanding the standstill. He then goes on to say, but you can't level down to the wrong treatment. You can't insist on being treated equally where the treatment you're relying on was the wrong treatment.
So that was a question of remedy.
That was a question of remedy. It was how did he decide the case, having identified the principle? And the taxpayer lost.
Well, there's lots of other law about perpetuating mistakes in tax.
It's about, in effect, do you level up or do you level down? And the answer was the taxpayer lost for the reasons that are given. But the principle that I rely upon here is his discussion and his approval of the judge as to whether fiscal neutrality necessarily offends the standstill. Answer, no. Are there cases in which it is merely a matter of interpretation rather than extension? Yes. Was that one of them? Yes. But that didn't get the taxpayer home for a reason that was peculiar to the sub 1 appeal. So when I said a moment ago that that nagging doubt about whether you could apply fiscal neutrality in the zero rating field, where it might have the effect of conferring zero rating on something that had hitherto not been zero rated as a domestic matter, is answered by this court in sub 1. That is not a principled objection. And so if the court is against me on my first argument for a reason that relates to the UK statutory code, so that at the end of that first argument, I am left with digital R standard rated, printer zero rated, then if I have persuaded you that they are comparable in the fiscal neutrality sense, they satisfy rank, and I say in effect with respect, that is this case, that's a matter of fact, then I can rely on the fiscal neutrality principle to get me home. So that was why it was always a fallback in the first tier. It was a fallback in the second tier, we didn't need it. First Tier decided that we were wrong about this, but with respect to the First Tier, what they failed to take fully on board is the import of this court's decision itself. So that's what we say in relation to the second way we put the case. And I'm afraid that has taken me a little longer than I had anticipated, but drawing the threads together, you will have my submissions as to why and how we get home on the first route. You've just heard from me on the second route, unless I can help you further those ones. I'm told there are 3 points. Mr. Brown reminds me that we should perhaps provide the various recitals to the introduction of electronically supplied services to the court, but particularly with my lady's question in mind. We will do that.
Please.
My Lord, you asked about Article 402.
Yes.
The transitional provisions of that. We can provide a copy, but that can be accessed through the footnote to our note.
Well, I tried and it couldn't be, so
In that case, we will provide you with a copy.
please.
And just harking back to a debate we had a little while ago, the point is made from those behind me that it's not necessary to cut the price of an item to promote democratic accountability or literacy. My clients would believe that they were furthering those objectives by continuing to provide high-quality news journalism.
It's more attractive to cut the price, though.
That's a debate that will no doubt play out under the heading of unjust enrichment.
Well, that's what I thought.
There is actually one other point. I answered, I think, my Lady Justice similar yesterday about the date of the Wapping strike. It was 1986.
Oh, was it?
Yeah, so it's later than I remember.
Good, yes, Mr. Fleming. We haven't got anything else. No.
Thank you.
Well, I'm very happy to use the 5 minutes to make some preliminary submissions, if that's helpful.
We're going to be more than 5 minutes, Mr. Fleming.
Slightly more, depending on judicial interest. Could I start and try and grapple with 2 European points? One is the relevance and impact of Article 98. We do not say, and have never said, that 98.2, which deals with reduced rates, directly prohibits such a reduced rate being applied to electronic services. So 98.2 isn't a knockout blow. What it does show, and what we submit is important and helpful, is when one is considering a restricted construction, strict construction, whether or not that has been applied, and whether or not there has been an extension of the scope of a permitted time-limited zero rating in relation to books, newspapers, etc. And the submission made by News UK that the word newspapers should extend to electronic supplies. It is helpful, relevant, that the court looks at the different treatment of those very same supplies by the EU. And we've said in paragraphs 53 to 57 of our skeleton argument why the EU treatment of comparable supplies provides relevant context and analogy for the exercise of statutory interpretation, and particularly for the always speaking principle. Put another way, proceeding on the basis that Group 3 are a list of goods, and that Item 2, when passed in 1972, when fixed by European standstill provisions in 1975 and 1991, so taking those three dates, it was confined to paper publications, then the EU laws and judgments addressing the same subject matter, books on paper, books on physical means of support, electronic services, as we've seen, they all provide a strong guide or steer to the decision maker, here the commissioners first, and then the courts, as to what is outside the range of an always speaking interpretation. And could I pause there to just highlight what will follow slightly developed, is Malherbe-Tren continues to make the same fundamental error in his submissions. He tells the court that he is operating in a field bounded by EU principles. That's a dangerous analogy. What he's meant to be doing is operating in a field or a cage where the grass is part domestic and it's part European. So you can't, as he's been seeking to do, apply the always speaking principle domestically and then stand back and say, well, is this changed by applying a strict approach? Is it changed by the standstill provision? That's just wrong and disregards what Lord Wilberforce was saying about context, disregards what the Supreme Court is saying about context. You interpret strictly, and you may recall Malherbe-Tren said there should be a purposive construction to further the aims. Well, that's not what is said in SAE. Not what is said repeatedly by the CJEU. It is a strict interpretation, but it mustn't effectively destroy the objectives.
It's 1 o'clock, Mr. Fleming. Whilst I love the analogy of the mixed seed in the grass field, you may need to give us a little more colour about exactly how that works.
Of course, that was merely the I hope.
The introduction. Yes, 2 o'clock.